welcome to the gray area, 50 Shades of HR. My name is ltorres. I've been working with business owners for many, many years, dealing with so many HR issues. And as an HR person, you have the law, you have the HR side of it, and then you have real life. You have the things that you have to deal with on a regular basis, human situations. And that's really why we created this podcast, was to deal with the gray areas. It's not always black and white. There's always a gray area. And today's topic is politics in the workplace, which can be a really heavy gray area. And I'm joined by my co-host here, Carlos Ledo, with the Ledo law firm, to discuss it. Carlos is a labor and employment attorney and also has backgrounds in different types of law.
Yeah,
I've tried immigration. It all. You've tried it all. And so today's topic, our first episode was about immigration, ICE coming to the workplace, right? And kind of begins to stir up political conversations, and people are very passionate about politics, especially nowadays. It seems like it's more passionate now than it was 10, 15, 20, maybe it just seems to be for me because of the media coverage.
I think you're right. I think most people now, it's become kind of like rooting for your favorite football team. Mm-hmm. Like they can do no wrong, and you're a diehard, Dolphins fan, Raiders fan, whatever the case may be. It's no matter, you're on one side and the other, and there's no middle ground anymore. There's no coming together to sort of meet in the middle and figure things out. Now it's just like you stand strong on your point, and you wear your team's helmet, and you don't take it off.
So when it comes to politics in the workplace, people can be very passionate about that conversation, like you're saying, like very passionate about their team. So in this case, their political party, or however they view it. Doesn't have to be a political party either. It could be a particular circumstance like immigration, right? You may feel very strongly about immigration. At what point does that, when you're talking about it at work, and let's say you and I are working together, and I'm like, hey, I'm for this party, and you're for that party, and your party stinks and my party's better. At what point does it become a problem, I guess, for an employer when you have people having that kind of debate?
Sure. And I think the main sort of entry point to the conversation is the First Amendment, right? Because everybody says, I have a First Amendment right to free speech. I could discuss political parties. I could discuss my political views. I have a right to do that as a citizen based on the Constitution of the United States. And you can't stop me from doing it, even in the workplace, which unfortunately is incorrect. Public employers, so government employers, right? Government agencies and employee individuals cannot stop free speech, right? The government cannot chill free speech, it's called. But private employers have a right to limit free speech or even restrict it completely when it comes to political speech in the workplace, because it is a private environment. They are not the government per se. They are a private employer that has a set of rules that they can follow. So employers, I think the first step for employers is determining what sort of leeway you want to give your employees, what sort of a roadway you want to give them in terms of how much they could speak about it in the workplace or not at all. And I think that needs to be outlined in your employee handbook in terms of what your sort of guidelines are for communicating about things like politics in the workplace are. So keep in mind, as an employee, you can't just go in there and start going crazy for a political party, running up and down, and not expect any discipline from your employer. If your employer has outlined the fact that they don't want political speech in the workplace, individuals communicating back and forth about politics, elections, specific topics, they can go ahead and discipline you for that now.
And I guess that goes along the lines of it being disruptive to the workplace, right? I mean, that's really the basis of it, because you don't want to disrupt the workplace. Like even when it comes to, in a future podcast, we'll talk about like religious freedoms at work, or even having inappropriate things up at your desk that becomes disruptive, to the workplace, right? Is that I guess that's a premise for it, so people understand why can I limit your political conversation?
Because ultimately what the point of being employed and the pride of a private employer hiring employees is to execute a specific job function.
Correct.
Right. So anything that distracts or takes away or impedes the ability to perform that job is something an employer can regulate and eliminate. So the purpose of the employee is to do their job, and the purpose of the employer is to pay the employee the wage that they've agreed upon to doing that job and provide a safe environment to do so. If the employer feels that an employee is being disruptive or activities taking place in the workplace are disruptive, they can discipline employees or chill that or find ways to sort of restrict that activity.
Where's the line? So I guess, so to speak, like if we can having conversations with you or anybody about politics in the workplace, where's that line where the employee's rights are not violated to where the employer's rights begin? Like, is that that's a gray area? Maybe
it is. It's a gray area, and I think it's subjective in a lot of ways. Yeah. But I think the one thing that is legally protected is, even in a private employer, if an individual is trying to unionize or if they are trying to give advice about who to vote for because it will improve their specific work conditions in the workplace there, or if they want to discuss things related to wages or anything related to their work environment or conditions, those things are protected by law. However, then if you teeter on, specific candidates or platforms or things of that nature, then that's sort of the gray area there. Now, I think it's difficult and probably impossible to stop people from discussing politics in the workplace or really restrict what their speech is as they're discussing things with their coworkers. I think it's just a rule of thumb to always just say, we want to have respectful conversations in the workplace, whatever the topic may be about, whatever the content. We want to make sure that our goal is to treat each other the same way we expect to be treated in the workplace. But most importantly, that we don't restrict or impede each other's ability to do our jobs or feel unsafe in the workplace. We don't want individuals coming to the workplace feeling like they're being attacked for what they believe or what they think. So let's make sure that we are careful in terms of how we operate and what we discuss in the workplace.
So when it comes to an employer and the employee handbook, can they take different positions? Like, can they ban it completely? Can they allow it? What can an employer do as, if I'm an employer and tomorrow I want to make sure I establish this or address this before it becomes an issue.
Right.
What can they do?
You can ban it in the handbook and say we do not allow political speech in the workplace as long as it's not protected by law, federal or state law, right? So any political speech that is protected by law in the private workplace, we allow. Anything beyond that, we do not allow. And we will take necessary action based upon the violation of the company policy, obviously in response to the level of the violation. So if an individual just has a conversation, it could be just, hey, listen, let's not talk about that. That's, we talk about this in our employee handbook. You signed off on it. We don't want to have discussions in the workplace because it could lead to disruptions. It could lead to conflict in the workplace, and that's why we don't want to have that. Or it could be somebody just coming in, let's say with a political party, just a shirt on, a hat, or whatever the case may be, and wanting to stir up trouble in the workplace and creating an issue. At that point, you could sit them down and say, listen, you violated workplace policy. We're going to give you a written warning for this as a result of your violating the policy because you've come in and disrupted the workplace in a manner that requires us to respond appropriately.
Does it? I mean, I know there's discussions, then there's arguments. Is it ever considered harassment? Can it become
it can. Harassment? I mean, if you are, the definition of harassment is treating someone in a manner that makes them feel unsafe, right? So if someone is coming to the workplace and let's say for whatever reason, another employee is attacking them for their political views or what they feel their political views are, and that's illegal. You cannot treat somebody differently based on their political views or national origins, religious beliefs, things of that nature. Especially the employer can't do that. But if an employee that's at the same level or within the organization is attacking them for those reasons, that's harassment, and it could lead to something criminal, depending on how advanced it is and how unsafe the individual feels or whatever the case may be. But harassment is just that basic, constant attack for your either gender, political views, religious views, whatever the case may be. And that can rise to something criminal.
What about, let's say, for example, as an employer, let's say your employer or an employer has certain political views and knows that certain employees don't. And maybe that employee feels like they're being treated differently because of their political views. Is there any legal protections from that perspective for
well, again, now that's something that an employer needs to watch out for. It's because if an employee feels like they're being discriminated against based on their political views or political affiliation by the employer, then they have a legal cause of action. So as an employer, it's really comes down to treating all employees equally, right? And in terms of how far you can do that. Obviously, different people you interact with different ways, but for the most part, in terms of treatment under the rules and guidance of the policies and procedures in your handbook, everyone should be treated equally. So for instance, let's say you believe in one political party as an employer and you have an employee that obviously is on the opposite side of that. If they receive more harsh discipline for an equal act than somebody else that's affiliated with the same political views that you have, then obviously now they've been discriminated against.
Gotcha.
So they can take that now to the EEOC and file a complaint and have that action taken.
Wow, that's crazy.
So again, now we're talking about acronyms and stuff. Let's go back to the EEOC. It's the Equal Employment Opportunity Commission, and that's an agency that's responsible for ensuring that employees' rights are upheld within the workplace.
Gotcha. What about an employee who actively posts on their social media? That's a big thing. You go on Facebook or Instagram and you see people posting, reposting, stuff like that. And some may be very extreme in their opinions and stuff like that. Can an employer restrict that in any way? Or maybe if the employee's wearing a company shirt or they're representing the company anyway on their social media, where does the line draw when it comes to that?
The line becomes where, like you just said, I think if they are representing the company in some way, then obviously the employer can take action even though it's their personal social media account. So if you're doing it within the workplace, let's say in your cubicle and you're clearly at work and you're posting these things, the employer can take action. If you're wearing a company shirt, company logo anywhere, they can take action. If your social media is used on a regular basis to promote your employer, that can also be something that can be used where the employer says, well, listen, we don't want us mixed in with your personal social media. You are now crossing the line in terms of violates our personal code of conduct in terms of our handbook and our employee policies. You need to take that down. And ultimately, if it crosses a line where it becomes threatening or illegal in some sense outside of the workplace, then that action can be taken.
So the focus should be basically on make sure that we're not doing anything that disrupts the workplace, that we're following the basic policies of the company, like no acting unprofessionally, not arguing, not fighting, those types of things from an employee perspective. And as an employer, you can enforce it from that perspective.
Yeah, and it's the same thing as if you were like talking about sports, right? Mm-hmm. If I happen to be a Heat fan and you're a Knicks fan, right? And we're arguing constantly in the office, going back and forth.
Correct.
The employer can stop us from having discussions about
really
sports.
It's no different. We're just changing the subject matter,
right?
But we would still follow the same basic principles we would arguing, like you're saying,
exactly.
over a sports team
and if it's becoming disruptive, it can be stopped by the employer.
I guess when we're talking about politics in the workplace, I mean, would religious accommodations be similar to how an employer would handle that kind of a thing? Like if we pivot now to religion, I guess, so to speak, versus politics, because it kind of goes hand in hand, and it depends on how you look at religion and what's going on in the world right now and things that are happening. That kind of feeds a lot of the political conversations, so also the religion side of it. So is that, I guess, is that a hot topic, I guess, nowadays also would be the religious.
Yeah, absolutely. And I think it's very similar in the sense that you believe you have certain protections under the law in the workplace that don't necessarily extend to the private workplace. You do have protection under the law. Like, obviously, if you want to express yourself religiously, if there are certain things that you must do from a grooming standpoint in adherence to your religion, for instance, if you practice Islam and having a beard, or even Judaism, if you want to have a long beard, things of that nature that are grooming standards that may not meet company standards, but it's part of your religious culture and part of your religious practice, employers must allow the individual to be able to groom themselves in that manner. So if it's specifically for a religious purpose. Other instances are specific clothing that's worn, maybe hijab, things of that nature, that individuals may wear for their religious purposes, but maybe don't match up necessarily with the company code of conduct in terms of their appearance, right? Or what their uniform policy may be. The individual should be allowed to wear that because that's part of their religious practice and part of their culture that's integral to the religious culture. I think that dividing line is whether it's integral or it's optional in your religion, I think sometimes can also be the thing.
Is that where that bona fide occupational qualifier kicks in? Like to have them look, unfortunately or unfortunately, you can't, have a long beard because of the type of business that we do, the type of customer that we serve. Like, I guess, where's that line? It's just how do you...
Sure, I think if it's...
the BFOQ?
If it's a situation where the grooming standard for the religion is at odds with the function of the job, then obviously the employer doesn't have to hire that individual or place them in a position within the organization that's at conflict with that. So, for instance, if it's food prepper, like somebody that does food prep and the long beard, it's a health code violation, and they wouldn't have to now cover that beard as part of their job, and they refuse to, then obviously they cannot take the job because now we're violating the law by allowing you to keep that grooming standard. So another position must be found for them, or they shouldn't be hired in that role.
This is really also another gray area because it's like you're dealing with, it's like borderline, like you just sneeze the wrong way and you're discriminating.
Right.
It's having that documentation. That's why it's really important, again, to work with an attorney or, with a professional, an HR professional that can really help you make sure you get that dialed in your handbooks and stuff like that, right? Because I don't think that's something you really necessarily address. You do address dress codes and things like that in your handbook, right? But also what about religious practices or ceremonies that can affect the workplace? Like, where does that come into play? Sure.
Like, obviously, any sort of religious practice during working hours, it can be restricted, right? I mean, if there's something where, sometimes, let's say for individuals who practice Islam, they allowed to pray in the workplace? That has to be something separate that's not done within their own cubicle. They must be able to go outside of the office and given time to do it. They don't necessarily have to be able to do it within the office, but they should be allowed to be given time to be able to step outside and do prayer, since they have to pray 5 times a day. That's part of the religious practice, and use a prayer rug to do that. So they go outside and they can find a spot to do that. Some companies may provide, at their own choice, if they decide to do that, a specific room for them to do that in if they choose to. but they don't have to do that by law.
So what's reasonable accommodation, I guess, from an HR perspective? That's a term that we use to determine whether or not, something can be accommodated for an employee, or even undue hardship. Like, where does that come in?
And that's the line right there. It's undue hardship. If something is placing a burden on the employer, right, on the company, that shouldn't otherwise be placed upon them. If it's a bridge too far in terms of the operational cost, in terms of the labor cost disruption that it's causing, then that's not reasonable. Reasonable means that the employer can easily accommodate the request by the employee, and it's protected under the law. Undue hardship becomes if that request now is, it's costing me $1,000 a month to be able to do this for you. That's a big impact on the bottom line. I shouldn't have to do that. That's an undue burden. If this is taking away manpower from specific employee functions or job functions that we're conducting on a daily basis, and it's now causing us to be behind in terms of our productivity at work, then that's something that needs to be also looked at, and it is not reasonable. But there has to be an evidentiary case that an employer can make that's documented to say, okay, this is an unreasonable request. It's creating undue hardship on the business, and these are the reasons why.
Yeah. What about, can an employee use religion as a way to avoid work or not coming into work?
They can. So, like, for instance, let's say a Jewish individual is going through a period where they cannot work past sunset, right? They have to be home by sunset, and the job is requiring them to work past, into the evening. They can say, because of my religious practice, because of this observation period, I cannot work, past sunset. I need to be at home by the time the sun sets. That is allowable. That's a reasonable request. And just the key to that is obviously having these discussions with the employees on the front end, the employees bringing these concerns to the employer as well, to let them know these are the restrictions that I have during these periods. These are my sort of restrictions in terms of my ability to do certain things within the workplace. And again, as long as it doesn't create an undue hardship on the employer, then it should be accommodated.
What about religious conversations at work? Like, taking part in religious conversations, like political ones almost, I guess, would be the same.
Right. It would be the same scenario as the political speech. I think this can get even more intense sometimes in politics.
Of course.
So, but, there is a certain level of protection. So if you have a Bible in your cubicle, that's okay. Maybe even some religious iconography. If you want to have a crucifix at your desk, or some other, if you want to have a Quran at your desk, or whatever the case may be, you can do that. But now trying to engage in political and religious activity in terms of religious conversion, speech, having communications with individuals that are condemning them based on their religious views. Those are things that shouldn't be done. That's outside of the scope as well.
What if an employee is offended by that? By having that thing on your desk, or whatever, somebody's offended by that, or offended by something you said, or something where how do you deal with that?
You have a legal right to have those things at your desk. If an employee feels uncomfortable, that's a conversation they can have with management and see if there's something that can be worked out, some sort of a compromise between the individuals. But I think ultimately, this is where sort of your guidelines and policies guide you as an employer. Do you allow those things? Do you prefer them not to bring it in? But ultimately, I think it's working in unison with your employees to make sure everyone feels comfortable, and seeing if you could find sort of a happy medium, some sort of a compromise.
Is it a good idea to address this in your handbook? Because I feel like sometimes if you put if you say too much in your handbook, you may be hurting yourself. Is this better to maybe avoid having conversations that are disruptive to the workplace, and then maybe speak about it? When you talk to the employees about it, like, hey, this is how we feel about politics, religion, sports teams, anything that's disruptive to the workplace, you're not allowed to do.
I think it's good to have a framework, but not be specific, because you want to deal with these cases, with these instances of, where we're talking about political speech, religious speech. These are things that are very specific to individuals and very specific to those religions. So where you think you've solved one problem, you may have created 10 other ones. So you want to keep it open and deal with it on a case-by-case basis.
Gotcha. And what are some things that some mistakes that employers make in this area, or do accidentally, unintentionally, that may be getting them in trouble? Would it be trying to limit conversations? Like, what are some of the things that you see, like, in this area, lawsuits or things happen?
Right, yeah. Lawsuits happen where individuals are being sort of restricted from observing religious practices, like we talked about, if they need to be home by sunset, or if there's certain specific religious practices that they need to adhere to that require them to take time off from work or miss work events and things of that nature, and then they're punished for that. That's the main thing that gets employers in trouble. You could obviously restrict the speech in the workplace. You have that right as an employer, but going beyond that and sort of enforcing your maybe religious beliefs, or outlawing specific religious beliefs and allowing others, is definitely something that will get you in trouble, because it is illegal.
But as an employer, when you're hiring people, you're going through the interview process, you have to be careful to not hire somebody for that reason specifically,
Right.
but shouldn't I have the right to know as an employer that, hey, I'm going to hire you, but you're going to be asking for this time off, I guess, or you're going to be asking me for time off during the day to go pray. Should I be made aware of that during the interviewing and the hiring process? Because I can't ask the question, right?
You can't ask the question, but you can ask, are you able to perform the functions of this job without
Gotcha.
restriction? Right?
Gotcha.
So that's a way around the question, and then they could volunteer the information.
Yeah.
You need to also be specific as to what those functions are or what's expected of the person on a daily basis. If you have a job that may require working evenings, that's an essential job, function of the job on occasion, maybe not all the time, but on occasion they'll have to work evenings. You need to make the employee aware of that and say, would that be an issue for you at all? So they need to then disclose, yes, it can be because of these factors.
Gotcha. Yeah, because I think that's very tricky, right? In how you ask the question,
Right.
So it's basically more about, here's a job, here's the hours you have to work, can you perform the job function? They may say, yeah, I can, and then you come to find out later on they're
and then you have to deal with it at that point. But I mean, the best you can do is, and I think with anything when it comes to being an employer, is be transparent. If you expect transparency from the employee, you have to be transparent as an employer.
Yeah.
So you need to be detailed in terms of what you expect this individual to do, what their job functions are going to be,
Right.
what the restrictions may be in terms of their personal life. What do we need you to do, and what is that going to entail from you on a daily basis, or even on occasion? What are we going to need you to do?
When I work with employers all the time, I tell them, working with somebody in the workplace is like, it's a relationship.
Yeah.
And communication is key. It's the most important thing. And if you communicate to people what your expectations are, where they're going, what's going wrong, or where they're not meeting your expectations, or if they're doing great, we don't give the feedback a lot of times when they're doing good stuff for us.
Yeah.
So I think that what you're saying is important, a clear communication of what your expectations are. And if you keep it to what your expectations are in relationship to the job, the function of the company, the company's mission, everything you're trying to accomplish, and stick to that, it avoids you, I guess, getting in trouble from a political standpoint, religious standpoint,
Right.
I guess those different areas.
And I think, like you said, it's true. You're building a relationship with this individual you're bringing onto your company. You as an employer expect loyalty from them, right?
Yeah.
But that's a two-way street.
Yeah.
So loyalty requires communication and a trust, and to build trust, you need to be transparent.
Yep.
And you need to establish that line where it's not like you're telling the employee one thing, but then you come back and do something else, or you didn't tell them the full truth. You didn't tell them the full sort of functions of their job, the full job description, what it really was going to be like when they get into the office.
Yeah.
Those are things that sort of violate trust and then start creating the rift between employee and employer.
This is definitely a gray area. This is definitely one of those big, that's why this podcast
This checks
was
the
made.
box on gray area.
For the gray areas. Okay, that's awesome. Well, thank you so much. Again, this is the gray area, Leo Torres and Carlos Ledo with the Ledo Law Firm. I think it's important to be able to consult with a labor attorney if you have this kind of an issue in the future when it comes to politics in the workplace, or work with an HR outsourcing company to help you put these policies and procedures in place and get your handbooks in place and make it happen.
Absolutely.
Great. Well, thank you guys for joining. See you in the next episode.